I salute you all. Thanks for listening and thanks for watching. So basically today I'm looking at we are under the law of torts and we are under trespass to person. Trespass and person, in this clip we are going to only explain assault and battery, the two concepts under trespass to person. And basically what you have to put in mind, or what you have to bear in mind, the two may mean the same, but they are different. You get trespass, but assault and battery, and the definition can separate it well. The definition of assault is that it is an intentional act that brings immediate apprehension to another person. What do I mean by immediate apprehension? It might be as immediate battery. You get, it can mean as immediate battery, but it is an act that will bring that immediate apprehension, that fear. You get, even though for assault, what you have to bear in mind, although assault and battery, they are combined under the PCA, which is section 227 and 223, actually relate to them in the PCA. So basically, for them, they under criminal, they don't specify. But under civil, since we are looking for redress and damages, we specify what assault and battery. You get, and for battery there, what you have to put in mind, battery there must be a contact. You get, so that is the difference. Under assault, there's no need of contact, physical contact, but for battery, there is need for what? For contact. You get, but however, the key ingredients and the assault and battery, they move together. You get, because the latter follows the what? Follows the other. You get, all comes after the other. It is after assault that brings battery. You get, so bear that in what? In mind. So when you look at assault, it has the following ingredients. First of all, the act must be intentional. The act must bring that immediate what? Apprehension. You get, the immediate apprehension must be what? It must be there, and the participation of the what? Of the accused person. Also bear that in mind to explain very well what assault means. So basically, and what must be proved under assault, you must prove that there was a threat to apply force. You understand? You must prove that there was a threat to apply force. What do I mean? There's a good case of Stephens versus Mayers. That's a good case whereby people were in a meeting of 6 to 7 people. So as a result, the defendant threatened the chairman of the meeting. You understand? He threatened the chairman of the meeting. As a result, he even wanted to do what? To attack him. But the person that was next to the chairman stopped him. So when the plaintiff or the chairman went to court, he was awarded damages on grounds that there was what? There was assault. You get, because there was a threat to apply force. But however much the force didn't reach, but the assault comes even before the force reaches to you. So long as it brings that immediate apprehension into you, it amounts to what? To assault. So basically, note that in mind. And also, we see that also there is when you are proving an order. You understand? An order that is what? That is coupled by a threat may mean what? An assault. You get, what do I mean? Here realize that there is a good case of Ansel versus Thomas. Here we see that a managing director was forced out of the premises of the company. His co-directors invited two policemen who told him that they could inject him out of the company if he did not voluntarily move away the premises of the company. So when he brought a case in court held that there was what? Assault. He was awarded damages because the threat was the order was coupled by what? By threat. So note that in mind. You get, and also even words themselves can amount to the what? To an assault. What do I mean that words can amount to an assault? When you read the case of Ara versus Ireland, that case of Ara versus Ireland and Baston, realize that here we see that the defendant made ridiculous phone calls to the plaintiff at night, and on phone calls he could not talk. So it brought fear to the plaintiff, of which it brought some mental illness to her. You get, so as a result, he could even not sleep alone. So when he sued, he was awarded damages because the act of the defendant amounted to what? To an assault. But however, they also say that words can negate what? Can negate assault, can remove assault. What do they mean? It is mere words, or the general rule says that mere words cannot amount to what? To an assault. You get, but those words must be accompanied by the threat. You understand? The threat, or that immediate, the possible threat outcome, or that immediate apprehension. But words can negate in a way that someone can utter a word and after revoke it. What do I mean? There's a good case of Taberville versus Savage. The case of Taberville versus Savage, here we see that the defendant put his hand on the sword and said that his act amounted to assault. Putting the hand on the sword and wanting to do something amounted to an assault. But however, he said that if it was not the Aziz time, you understand, I would not take such language from you. You get. However, you see the words themselves, they show that he was not to act. But he said if it wasn't the Aziz time, he would act. Which means his words were, and his act was an act of assault, but his words revoked the assault, so whereby the court held that there was no act of of assault. So bear that in mind also. And basically also what you have to know that the words also put ahead, or the words put across, that they are put to a reasonable man in fear of a battery. A reasonable man must be fear of battery, or for that immediate apprehension because of the words that are being put. That's why they say that mere words cannot amount to what? Cannot amount to assault. You get? So that is some of the kind explanation that I can give to assault. Then we have what we call we can say about battery. As I said, that battery is the intentional application of force, or force to another person. You get, for battery, the difference between assault and battery. Under battery, there is what? There is force, application of force. However slight it is, it amounts to a battery. Since for so long as the plaintiff or the other person didn't have consent about that force. You understand? Even if it is hostile, it may be hostile, it may be direct or indirect. So long as there was no consent of the other party, it amounts to battery. You get? And some of the ingredients, there must be application of force, there must be intent, and there must be a participation of the plaintiff. And basically the good case that can bring out that concept is the case of Collins versus Wilcock, where the police officers found two prostitutes, and they knew the other one didn't know. As she was walking away, she followed her. When she followed her, he tried to touch on his shoulder. Then the other one removed the hand and scratched her accidentally. So he sued for assault. But whoever court held that there was battery, since the other one owed the rug, that was not in accordance with what the police officer could do. So the police officer was liable for what? For battery, because there was contact. You get? So the issue was whether taking hold of the woman's hand was lawful or was battery. So the court held that it wasn't lawful, it was a kind of of battery. So basically not that difference under battery. Under battery, there must be application of force, there must be an intention to apply force. And anything that calls for contact, it is a form of It's a form of battery. So basically note that in mind. And also battery, it is also in a form of in a form. So bear in mind the act must be involuntary, the contact must be involuntary, battery must also be intentional, reckless or negligent. Battery need not to be hostile. You get? And also there is also where they say that battery may be committed to someone that is unconscious. You understand? Then basically that points us to the consent of what? The consent to treatment. For doctors to make any operation on the patient, they must first get consent of the patient or get consent of someone that can consent on behalf of the patient if the patient is a what? Is a minor or is a child. So basically, if a doctor does an operation without the consent of the what? Of the patient, then that is a form of what? Battery. Note that in mind also. So basically note that any medical doctor must first get consent of the what? Of the patient. There is a case of Njareketa versus director of medical what? Medical services. This is where a patient had what? Had a malignant what? Leg. Growth on his leg. So he first consented at the operation, but later withdrew the consent. So when he was asleep, unconscious, the doctor made an operation and cut off his what? His leg. Then the court held that it amounted to what? Battery. You get? The act of the doctor amounted to what? Amounted to battery, obviously. So that is to deal with assault and battery. You get? Know the difference? Look for the favorable cases to back up your explanation. Because tort law is all about what? Cases. You get? Cases are the ones that back up your argument in any essay or in any exam. You get? So basically note that in mind. You get? About assault and battery under trespass to person. So trespass to person is a tortious what? Liability. Though we have 3 more. You get? So basically, I beg to end here for today's series. We end here, and anyway, anything that you don't understand, please put it in the comment section. I can highlight more. Sometimes I realize that not every weak point or not every confusing point that I can oversight about it or I can explain about it. But if you put a comment, I can open my eyes to it. So thank you for watching.